So if you want to know exactly what you can expect from October 3rd, this is it. So October 3rd isn't about headlines, it's math. 2 counts, 1 judge, and a clock that's been ticking at Metropolitan Detention Center while everyone argues about what the number should be. He beat the biggest charges, but 2 Mann Act convictions still sit there like weights. Concurrent or consecutive. That flip could turn years into months. Let's talk real outcomes. Here's the scoreboard. The jury cleared him on racketeering and sex trafficking, but found him guilty on 2 counts tied to the Mann Act. Transporting someone for paid encounters. Different statute, different proof, different consequences. That's why you saw the split. Now people hear max 10 years per count and start doing panic math. Slow down. Statutory max is the ceiling. The sentencing guidelines decide the neighborhood. And the guidelines don't care about your timeline on X. They care about offense specifics, what the judge believes happened, and how the pre-sentence report lines it all up. So yes, huge charges fell away. And yes, 2 didn't. Both can be true. The result is a narrow lane where small details matter a lot. Think enhancements, adjustments, and whether the judge buys parts of the government story even without convictions on the biggest counts. That's the quiet part most folks skip. And it's exactly where the number comes from. But that wasn't the whole story. Here's where the number gets built. The sentencing guidelines start with a base level, then stack adjustments like Lego bricks. Did the court see signs of pressure or harm? Were there multiple people involved over time? Were encounters recorded? Did anyone try to hide evidence or intimidate? Each yes bumps the score. Prosecutors push for those bumps, arguing the pattern was bigger than the 2 counts. The defense fights to strip them out, stressing consensual context, the split verdict, and character letters. That's why you hear 2 very different ranges from smart people reading the same case file. Both can be right, depending on which bricks the judge allows. Now the judge isn't guessing. He has a pre-sentence report, memos from both sides, and he'll announce his math in open court. That single explanation, base level plus what stuck minus what didn't, will tell you almost exactly where the sentence lands. And yes, it can swing a couple of years either way, but the range is only the map. The judge still decides the route, concurrent or consecutive, time served, credit, and conditions after release. And that's where the years can shift fast. Here's where the clock really moves. 2 counts mean 2 choices, concurrent or consecutive. Run together, the headline number shrinks. Stack them and the math grows fast. That single call can flip a timeline more than any tweet thread ever will. Next lever, credit for time already spent in custody. Whatever number the judge picks, time at the Metropolitan Detention Center counts after sentencing. It doesn't mean walk out today, but it matters. Then there's variance. The judge can go a little lower or higher than the guideline range if he explains why. The memos try to steer him. Prosecutors say risk and harm. Defense says context and character. After that, supervised release. Think conditions, counseling, travel limits, computer rules, check-ins. Break them and you're back before the same judge. Fast. The court can also layer on financial penalties. We'll talk dollars in a minute. And no, he's not heading straight to some cushy camp. He returns to the Metropolitan Detention Center, waits for BOP designation, then gets shipped where the Bureau decides. Different world, different routine. So yes, the guideline range sets the lane, but these levers decide the ride. Sentencing day runs like a script everyone in that room already knows. It starts quiet. The judge takes the bench. He confirms the convictions and the paperwork on record. Then the floor opens. Victim statements first, short, direct, and heavy. The government follows, hitting their guideline math and any here's why higher moments. Defense comes next. Expect character letters, health notes, work history, and a reminder that he was cleared on the biggest counts. Then the wild card. Does he speak? He can. A short statement can help. Accountability without relitigating the trial. Too long, too defensive, and it backfires. After that, the judge walks through the numbers out loud. Base level, enhancements he accepts, anything he rejects. This is the part to listen for. It tells you the range before he even announces the final number. When the sentence drops, it's not just years. You'll hear whether the counts run together or back to back, supervised release terms, and any financial penalties. The marshals do their job. He returns to the Metropolitan Detention Center while the Bureau of Prisons picks where he actually serves. No dramatic hallway exit, No cameras, just paperwork and a transport date. Here's the range that actually matters. Scenario A, the lower lane. If the judge lands near the defense math, you're looking at something around 2-ish years. Subtract the time already spent at the Metropolitan Detention Center, and it feels shorter on paper. But no, he's not walking out the door. There's post-sentencing processing, Bureau of Prisons designation, and the slow gears of transport. Good time credits exist, but they don't erase a sentence. They shave it if you follow every rule. Scenario B, the mid lane. If the court buys more of the government's enhancements, the range stretches into the 4 to 5 year neighborhood. That pushes real calendar time even after credit and any later good time. The daily reality changes from how soon do I transfer to how do I manage years with structure, programs, routine, limited movement. Your world shrinks, then repeats. Now the big swing, concurrent versus consecutive. Run both counts together and you live inside one number. Stack them and the whole thing jumps. No drama needed, just a single word from the bench. Add in supervised release after custody, travel limits, check-ins, conditions, and the tail can be as heavy as the time. So yes, the internet loves predictions, the judge loves math, and that math turns on a few lines in a worksheet and one call on concurrency. Sentences aren't just time, they come with a bill. First, the special assessment. It's small next to the years, but it's automatic on felony counts. Then the court looks at fines. That's the pay the courthouse column. The judge weighs ability to pay, assets, and income. If the pre-sentence report says you've got cash flow, expect a number and a schedule. Miss a payment? They don't forget. Think wage garnishes, seize funds, and letters you won't like. Now the heavy part, restitution, different bucket. That's money to people, not the court. It has to tie to what the jury convicted on and what losses the record actually proves, not vibes, not headlines, receipts. If the judge orders it, it follows you long after the cell door opens, through supervised release, through new jobs, through that first I'm back brand deal. Probation will want a plan, monthly payments, proof of effort, updates. Blow off the plan and you're back in front of the same judge explaining why the check stopped. There's also the PR math no one puts in a judgment. Lawyers, crisis teams, lost partnerships, projects that pause for a year and never restart. Even if the prison number lands low, the cash meter can keep spinning. That's why the defense memos talk about dependents, charities, payrolls, anything that frames a lower fine or a softer schedule as fair, not lenient. So yes, everyone chases the year count. But the dollar line can bite longer. When the number drops, listen right after the years. That's where the second sentence lives. There's always noise before sentencing, motions, new evidence, think pieces. None of it stops a federal calendar. The court still opens at 10. The judge still reads a number. Here's the short list people keep arguing about. Post-verdict motions, the set it aside and give us a new trial filings. They exist. They preserve issues for appeal. But unless the judge says the magic words, he won't. Those papers live on the docket while the sentence lands. The same goes for the defense framing, calling filmed encounters amateur content, and arguing consent. That's appeal fuel, not a pause button. What about release pending appeal? Rare. You have to raise a serious legal question likely to flip the outcome. Most cases don't clear that bar. Judges know the standard, they quote it line for line, and then they say no. Could a pardon appear? Rumors travel faster than facts. Even if someone whispers about it, that's politics, not sentencing law. The court doesn't schedule around speculation. The hearing goes forward. The number drops. The marshals do their job. One more thing. You'll hear lawyers saying we object a lot. That's intentional. They're preserving every issue for the appellate record. Guideline math, enhancements, evidence the judge considered. It sounds tense. It's actually routine. Appeals run on transcripts. Every objection noted is a breadcrumb for later. So yes, there are wild cards, but they're after the gavel, not instead of it. On October 3rd, the story is simple. Guidelines, arguments, sentences. Then it's back to the Metropolitan Detention Center to wait for Bureau of Prisons designation while the paperwork war moves upstairs to the Court of Appeals. Criminal court hands down years, civil court chases dollars, different rules, lower burden, longer timeline. That's why the story doesn't end when the judge says the number. Plaintiffs file claims, defense files motions, then comes discovery, emails, texts, contracts, depositions. It's slow, invasive, and expensive. Some claims get tossed, some survive, and the ones that survive Push toward settlement, not closure. Settlements don't come with applause, they come with NDAS and payment plans. Now the business side. Partners hate risk, so you see pause, under review, or we've ended the relationship. Distributors step back, licensing conversations go quiet. Agencies rethink endorsements. Even if a deal doesn't dissolve, morals, clauses, and reputation language give counterparties exits. Insurance, maybe. Policies often carry exclusions for intentional misconduct. That means carriers can fight coverage or reserve rights. Translation, you can still be writing the checks. Meanwhile, the brand has to function. Payroll, projects, half done, back catalog decisions. Do you sell assets to cover legal drag? Do you restructure? None of that is glamorous, and all of it moves slower than social media thinks. And even if cases settle, the search results don't. That's the quiet damage. Introductions in boardrooms that start with a wince. So when the sentence drops, remember there's a second scoreboard off camera, case dockets, insurer letters, sponsorship talks, and spreadsheets that never go viral. If you're tracking this story past the gavel, watch those filings, not the rumors. They tell you where the money goes next and how long the drip lasts. If you're watching the live updates, 3 signals tell you the story before the headline lands. First, the judge's math. He'll say the offense level and criminal history category out loud. That pair creates the range. Listen for which enhancements he accepts and which he tosses. One enhancement in, you feel it. One enhancement out, you feel that too. If he mentions a variance up or down, that's your clue the guidelines aren't the final word. Second, the single word with the biggest swing, concurrent or consecutive. If the counts run together, the sentence shrinks to one main number. If they stack, add the numbers, then add a little patience, because that's years. Watch his reasoning. He'll tie it to conduct, harm, and the structure of the counts. Third, does he speak? A short direct statement, no excuses, no relitigating, can soften edges. A defensive speech can harden them. Judges read tone, they also read the room. After that, track the financial orders, fines, the special assessment, and any restitution. The court will set supervised release conditions too. Travel rules, program requirements, tech limits, check-ins. Those shape the next chapter more than most people think. When the number drops, the marshals handle custody. He returns to the Metropolitan Detention Center while the Bureau of Prisons decides where he will actually serve. That designation takes time. Expect quiet days, not dramatic scenes. The next public movement is a bus, a holdover jail, and then a final facility. The internet will shout. The system will crawl. Here's the straight answer people keep skipping. This outcome isn't vibes, it's math. The guideline calculation frames the range. The concurrent versus consecutive call flips the length. The credit for time already served trims the calendar, not the conviction. Add supervised release rules and whatever dollars the court orders, and you've got the full picture, time, tail, and tab. After sentencing, nothing flashy happens. He goes back to the Metropolitan Detention Center. The Bureau of Prisons picks a facility, programs, routine, restrictions that becomes the day-to-day. Meanwhile, civil cases keep moving, partners keep reassessing, and the brand cost keeps ticking where cameras don't reach. That's the real split screen, a criminal sentence on one side, a long financial and reputational grind on the other. So when October 3rd ends, don't just ask how many years, ask which enhancements stuck, whether the counts ran together, what the judge said about restitution, and what the conditions look like after release. That's the roadmap. We'll break the numbers into real-world time the moment they're announced. How much is left after credits, what BOP designation means, and what to actually expect next. From the inside, October 3rd isn't a date, it's a finish line he keeps staring at. After the split verdict, Diddy was visibly shaken in court, then told his family, "I love you, I'ma be home soon." Hopeful, a little defiant, and very public. That's the tone his camp has pushed ever since. Day to day, he's still at the Metropolitan Detention Center. No bond, no sunlight, lots of noise about rough conditions. His lawyer says they talk often and that the focus is simple. Get the best number possible on October 3rd. Translation, keep expectations tight, push the lowest guideline math, and bank every mitigating detail the judge will hear. What does Diddy actually expect? His team keeps signaling a shorter sentence. think 2-ish years in their ideal math, with a push for alternatives like home confinement and mandated counseling on the back end. It's the "I can rebuild if you give me a lane" pitch, and they floated it in interviews, in tabloid hits alike. Whether the judge buys it is another story, but that's the ask. Emotionally, it's a split screen. On one side, the public bravado, the fist pump for the acquittals, the "home soon" line, the family first messaging. On the other hand, a legal reality he can't control, sentencing guidelines, a judge who already denied bail, and prosecutors arguing the range should be higher than 4 to 5 years. Hope meets math at 10 a.m., and he knows it. Bottom line, he's aiming low and bracing. If the judge lands near the defense's range, it feeds that "home soon" promise. If not, the plan shifts to appeal, therapy, and a long branding rehab from a federal address starting right after the gavel. So subscribe to my channel and also like this video, as it helps a lot. There is a ton of misinformation out there, so you might want to subscribe to the real deal.